Hey everybody, welcome to Local Law 144 for AI governance professionals. My name is John Rood. I am the founder of an AI governance consultancy called Perceptual. I have personally conducted many New York City Local Law 144 audits. I've implemented AI governance programs and conducted these audits for clients of all sizes, from like pre-revenue startups, Series A startups, publicly traded, private equity backed, all the way to like global top 50 international conglomerates. So I've done a lot of these over the years. I am the lead instructor of Michigan State University's AI Governance Certification Program. And importantly, since we are going to be discussing rules and regulations and laws today, I'm not a lawyer. I'm definitely not your lawyer. Nothing today is legal advice, and you should talk to your own lawyer about these issues. So, what are we going to get out of our discussion today? By the end of today's video, you should be able to, depending on who you are, if you are a leader in an organization, you're a CISO, you're a general counsel, you're an AI governance lead, you should know whether your organization needs a local law 144 audit. If you are like me, a consultant or an auditor, or you're getting into those professions, you should be able to understand how to conduct a local law 144 audit for your clients. And then if you are an aspiring AI governance professional, like you're upskilling into this role, and I'm recording this in part for my students in my course, you should understand what AI governance professionals actually do in this context. And, you know, from my experience, a local law 144 audit is sort of the easiest kind of audit to conduct that's required by regulation. So it's a great place to start to kind of get some idea of what this world actually involves. So we're going to go through the background on what Local Law 144 is. We'll talk about the requirements in the law. We'll talk about the bias audit and go step by step through that process. The bias audit is by far the most complicated part of the regulation. We will see how this applies to an actual company. We'll run a little teaching scenario. And then we're going to talk about, if you're interested in this topic, you're interested in getting into this kind of work, how to upskill into a professional role in this world. So first of all, what is New York City Local Law 144? It is the first law that regulates the use of AI tools in hiring and promotional decisions. It is called Local Law 144 of 2021 because it was passed in 2021, but it actually went into effect in 2023. The law applies to employers and employment agencies, and it regards the use of what are called automated employment decision tools. We're going to define that really carefully in a second, but it's important to know that you kind of see that language in a lot of different regulations now. It sort of started here in Local Law 144, but just know that you'll see that a number of times. The law applies to tools that are used to screen candidates for employment or for things like promotion or other kind of hiring decisions. And the law applies to jobs that are either located in New York City or are fully remote but associated specifically to a New York City office. So this law is actually drawn pretty narrowly and focused really on New York City. I mean, that said, like, lots of companies have offices in New York City, so this is not a small deal. So what is an AEDT? The law defines it as any computational process derived from machine learning, statistical modeling, data analytics, or artificial intelligence that issues simplified outputs, including a score, classification, or recommendation that's used to substantially assist or replace discretionary decision-making. So that's a mouthful. I'm not usually going to quote from the regulation at length, but this is really important because you have to get a sense of how we're actually defining these tools. Now, the part of this that gets the most attention is this substantially assist or replace language. And it means that when an organization is relying specifically on the AEDT with other factors considered, that is substantially assist. If the output is being considered as one of several criteria, but is weighted more than other criteria, that's substantially assist. And if the automated output is replacing other decision factors, that is substantially assist or replace. Now, as you can probably intuit, it's not actually particularly common for AI systems to like totally make hiring decisions all by themselves with no humans. So there is a pretty significant limit to what organizations this applies to, right? So if you are, an attorney, you're a general counsel, you're probably already seeing there's lots of common sense and reasonable ways to argue that your client's tool does not in fact substantially assist. But some examples of AEDTs on the left there, resume screening tools, AI interview platforms that have some sort of analysis or like behavioral scoring, chatbots that qualify candidates, ranking algorithms. And by the way, like basically every HR tool has ranking algorithms, like anything that has to do with hiring. So all of your HR information systems, all of your applicant tracking systems, they all do this now, like for sure. Whether or not it's substantially assisted is the question, but like they definitely do this ranking. And then there's a lot that's not covered, obviously, on the right side. So things like, for example, the second bullet point is a calendar scheduling tool for hiring interviews. If the calendar's not doing anything, it's not an AEDT, right? If it's just like if it's not ranking candidates or scoring candidates, it's not an AEDT. So, what are the three big requirements for Local Law 144? The first is conducting a bias audit. So this is a third-party independent audit. Now, when I say that, what it means is that you cannot be an employee of an organization and audit your own tools, right? So both if you work for the maker of a tool, you cannot audit the tool, and if you are the organization using the tool, you cannot audit the tool. So you have to hire people like me, and perhaps people like you, to do these third-party audits. Secondly, there is a public disclosure requirement. So the bias audit can't be like kept secret. You have to post those results on the company's website and link to them. And there's some kind of like requirements about how easy it has to be to find. You can't just totally bury it. And then finally, there's a candidate notification requirement. So candidates have to be notified that there is going to be an AEDT system in use. And this sort of transparency requirement is really common in regulations around the use of AI. So you'll see a lot of it and sort of originated here in Local Law 144. So let's talk about what that bias audit actually entails. So the bias audit, again, is conducted by an independent auditor, and it's testing for what's called disparate impact across these categories. So on the left, we're comparing sex categories, and on the right, race and ethnicity categories. Now, when I put these on the screen and talk about these groups, these group choices, and the language is directly from the law, right? So if you're listening to this, you're like, well, I don't know if it's sex or gender or whatever. I put sex there because like that's what the law says. So I always like talk about exactly what the law says. Now, we're also talking about the intersection of these categories. So not only are we comparing men with women, we're comparing Latino men against female Asian candidates, right? Which creates a lot of additional work and a lot of additional challenges. So what is the actual audit that we're doing? Well, there's sort of two flavors. And the first is what's called the selection rate. This is for AEDTs that have a pass-fail outcome, where some candidates are moving forward and other candidates are clearly not moving forward. The first thing we do is identify the selection rate. The selection rate is the number of candidates selected in a group divided by the total number of candidates in that group. So you see in the chart there, for men, there's 500 applicants, 300 are selected. So 300 divided by 500 is 60%. That's the selection rate. We run the same thing for the female candidates. That's obviously a very easy calculation. And then we're deciding on the impact ratio. So the impact ratio is the selection rate of the group that you're studying divided by the selection rate of the most selected group. So in this example, the most selected group is men. Their selection rate is 60. If we're testing women against men to find the impact ratio, we divide 50% by 60%. That's 0.83, and that goes in our impact ratio on the right side of the chart there. And ultimately, the point of this exercise is to get to the impact ratio. So that's the selection rate side. Scoring rate is determined for AEDTs that have a continuous or numbered score output. So these are not pass-fail, but instead we're giving a particular score. So think about like a pre-hire assessment and you get like a percentage or you get like a number, like, one person gets 12, one person gets 7 or whatever. That's the scoring rate. So to calculate the scoring rate, we have the number in a group that scores at or above the median of the entire group divided by the total number in the group. So we have to get the median score that all candidates get here. Again, let's look at the male category. 600 candidates are assessed. 348 are scored above or equal to the median. So we take 348 divided by 600. That's 58% is the scoring rate. We do the same for the female candidates. Then the impact ratio, again, we take for studying the female impact ratio, 52% divided by 58% is 90%, and that's the impact ratio. We almost always write the impact ratio there as a decimal as opposed to a percentage. Not exactly sure why, but that's what we usually do. Oops, sorry. There's no pass-fail standard for Local Law 144. Now, that said, the EEOC has a long-standing rule that the impact ratio has to be under 80%. And if it's not, then that creates a clear line for adverse impact. So going back a second, in this category, in this study, the females getting an impact ratio of 0.9, like that would generally be considered to be acceptable. Now, as we said, there's no clear line in Local Law 144. You just have to do the audit and post it. But that said, think about my clients. Companies don't want to publicly acknowledge using a tool that's under that threshold. Like that can be a big problem. So if you're getting adverse impact under the 80% rule, that's something that you want to probably correct. Now, this is a full bias audit that's selected by race and ethnicity. As you can see, there are more categories here, but the calculations are the same. We're calculating selection rate and impact ratio. Now, one little thing with the data here is that if a category is less than 2% of the total sample size, the auditor can exclude that from the calculation. You do have to say that you're doing that, right? So you have to call that out particularly. And this comes up a lot. And it comes up a lot because, if you look at our race and ethnicity groups, like in the entire US, some of these groups, there's just more of them, more people than others. And in particular in New York City, right? You think about, the makeup of New York City, there's a lot more Hispanic people, white people, and Black people than there are Native Hawaiian people, right? So in basically every one of these audits that I've done, we are excluding Native Hawaiians, very frequently excluding American Indians as well, and oftentimes excluding two or more races, although that happens more often than the others, just because there's not enough data. Now, we also have to figure out our intersectional categories. So as you can see here, like there are many intersectional categories. If you remember back to, we were just talking about that 2% rule where we can exclude categories with less than 2%. When we do the intersectional categories, there are a lot of those that are less than 2% of the data. So a lot of those are excluded. Now, that said, when you have more categories, you are much more likely to get impact ratios that are much more widely distributed. So oftentimes we'll have a category that's relatively small, but more than 2%, and the impact ratio is off. This is one of those things that creates a lot of challenges for auditors, and it also creates a lot of challenges for clients. And really, I guess that if I'm being honest, it doesn't create challenges for auditors because the auditor's job is just to do the report and to present the data. And we as auditors don't change the data. Like we can't modify what's going on. We just say what the data says. But then when we hand this off to our clients, they really have some challenges if these impact ratios, if many of them are under 80%. So what data is being used in the bias audit? This is again contained in the regulation. The best and most preferred use of data is historical data from the employer's use of an AEDT. So if you've been using tool X for 5 years, the best way to do this is to take the results of that data from the last 5 years. Now, that doesn't happen very frequently because oftentimes my clients come to me when they want to start using a tool or they've recently started using a tool and they don't have that data. So then we move on to number 2, which is historical data. So the creators of the platform of the AEDT can provide this historical data from other similarly placed employers who are using the same AEDT. Now, of course, this starts to create a little bit of challenge, right? Like when we are getting our data from the people that are actually making the algorithm, like there's a challenge there, but nevertheless, like that's what the law says. And then finally, we can use test data when there's no historical data available. So if we're using like a brand new tool, we can generate test data. There's some rules and some nuance around what test data we can actually use. But that's one of those things that auditors do is we use our judgment to think through, if we don't have access to historical data, what's the right test data set? How can we actually run it through the AEDT? There's a lot of challenges there. Then we have to take the results of the audit and they have to be published on the website. For me and for my clients, I almost always publish the audit results on my website and then our client links to them. That tends to be preferred because then it shows that an independent auditor had absolutely done the work, right? So like it's really clear. And then also like when we have to update the audit, which we do on an annual basis, it's not hard for me to go onto our website, take the new data and update the audit. But the results has to include the source and explanation of the data. So we just talked about data sources, the date of the bias audit, the number of applicants, the selection rates, and all of these things are just going to be in a chart, right? So the charts that we saw on previous slides, we're going to print those charts in our audit report. And then, of course, we have to make sure that to have the number of individuals whose race or ethnicity or sex was unknown and thus excluded. That seems like a little point, but it's actually a big point because many organizations don't keep this data, right? So many organizations don't like track the race and ethnicity of job candidates. So there's a lot of nuance there on the part of the auditor in figuring out like, do we have enough data? What do we do with all these uncategorized individuals? Additional requirements we have to have posted on the employment section of our website, a very clear transparency requirement showing the bias audit testing results, and that transparency requirement that these tools are in fact in use. So we have to provide, as we just mentioned, candidate notice. So how do we provide candidate notice? Well, there's this rule that says at least 10 days before the AEDT is used on the candidates, which is a little bit funny because if you think about how this actually works in practice, you apply for a job, and then maybe you get an initial screen and that's kind of from AI, like maybe that's a one-way interview or maybe that's a pre-hire assessment or something. So oftentimes there's no way to give 10 days of notice, right? And that's one of those places where this law is like not necessarily always written in a really clear way. But that said, you should give the notice if possible. And the way to do this is just to include the notice anytime you are using an AEDT, right? So anytime it's mentioned, anytime it appears on the website, just massive transparency is the best solution for this. We have to be transparent that the AEDT will be used, what job qualifications the AEDT will assess. We have to be specific about that. And then we have to talk about how the data is collected, and how the data is retained. So data retention is always a big issue in data privacy and regulation. So we want to make sure that we show what that is. Then finally, that last bullet there, like a little innocuous, but really important, we have to provide instructions for an alternative selection process. So we have to provide the ability for candidates to opt out of the use of the AEDT. Oftentimes, functionally as an auditor, this is just a line in the transparency statement that says, if you want to opt out, send an email to this email address that goes to our client. In practice, like of the dozens and dozens of these that I've done, I've never seen any candidate opt out. Maybe they did for my client, I didn't hear about it, but I've never heard of that happening. And then there's some instructions on how notice can be given. Like, yes, you can send this in the mail. Functionally, that never happens. What actually happens is you put this on the website, and if you're having someone do like a pre-hire assessment, when you send those instructions, you send the AEDT transparency notice then as well. There are significant penalties for non-compliance. The first violation and additional violations on the same day is $500. Each subsequent violation is $500 to $1,000. And these are daily, right? So every use of an AEDT in violation of the law is a separate violation. So in theory, there are significant penalties and they can really add up. Now, one of the things that is a real challenge for my clients and for us as auditors is New York City has not done a particularly good job of enforcing this. So there has not been a lot of penalties given out for this particular regulation. But that said, like these are in fact the penalties. And so, our clients come to us whether or not they are likely to be penalized because this is what the law says and they want to comply. And then finally, I want to place Local Law 144 in a little bit of context on the larger regulatory landscape. And this is mostly US focused, although European EU AI Act is on here as well. The New York City Local Law 144 has this bias audit and then transparency requirements. And then we see the transparency requirements lots of other places. So in Illinois, in Colorado, we have to do impact assessments. That's actually different from the bias audit. And so one of the things that's interesting is that the bias audit requirement that specifically to New York City Local Law 144, I have not seen that exact same process be used other places. So it's sort of like standing on its own a little bit, right? Like there's definitely going to be more regulation, but the regulation that's come to pass is mostly more specific and oftentimes kind of moving away from this EEOC style comparative selection rate bias audit that you see in 144. Okay, so how does this apply to a real organization? Of course, it's not really a real organization. I made this company up, but let's say that you are a mid-stage SaaS company headquartered in Manhattan. You use an AI resume screening tool that screens your applicants on a 0 to 100 scale and then advances the top 40% to the next stage. let's say that you are an external AI governance consultant, and this company has brought you in to do compliance. So what does the process looks like? First of all, we determine if local law 144 applies. Now, again, I want to say it really clearly. If you are not a lawyer, you cannot provide legal advice. I'm not a lawyer. I'm not providing legal advice, and I never do. So this is one of those things where you have to be in touch with the general counsel or the legal representation of your clients. But the questions that group, that party should be asking are, is the tool an AEDT, right? So in this case, it seems like yes, it scores candidates and it's advancing a certain percentage automatically. The next question is it used for a covered employment decision? Well, it's used to screen candidates for hiring. So yes, that is in fact a covered decision. And does the geographic scope apply? Like yes, Talent Screen is headquartered in Manhattan and it's hiring for New York City roles. So that is in bounds. So we would presumably believe that local law 144 applies and that we have to therefore comply with it. Secondly, we have to create an inventory of AEDTs. Now, some organizations just have one, like it's possible. In my experience, most organizations have multiple AEDTs in use, so we have to have all of them, right? So if we're a brand, we're the HR department of a large company, we probably have multiple tools that are AEDTs. So we have to understand what are all those, what are the functions, and then are they in the scope of our engagement? Some of them will be, some of them won't be. So in this example, in the chart, calendar sync is just scheduling our interviews. That's more of an administrative function. It's not actually ranking candidates, therefore it is out of scope. So we have our AEDT inventory. Then we're working with our independent auditor, right? So in this situation, the independent auditor is you, but it's really important that you have independence. So if we think about what makes an auditor independent, the auditor can't have a financial interest in the employer and employment agency that use the AEDT. They can't have a financial interest in the employer or the agency if it's an agency, and we can't have a financial interest in the vendor that develops the AEDT. Functionally, like this isn't usually an issue, but it is important in your audit report that you specify that you don't have these entanglements. So I'll just have a couple lines that says, I have no financial interest in the employer, in the vendor, etc. Let's move. So who performs these audits? Well, there's lots of audit firms. We're one. There's lots of others. You also see psychology firms do these. You see a lot of large consulting firms do it, and I've seen lots of independent data scientists do this. So if you're wondering, like, do you fit into these categories? Like, yes, like if you are interested in creating a AI governance consulting practice, this is kind of a well-trod way to start that work. Then we actually do the bias audit. So we've talked about that before. We are going to calculate the median scores. We do our calculations across demographic groups. We calculate our impact ratios. We do that for sex categories, for race and ethnicity, and for intersectional categories. And then we create our report. I'm going to show you a way at the end of our discussion today that you can actually get my sample bias report. So hold on for that. Then we have to publish the results. So Talent Screen has to get the audit done and then post on their website. So we put the source and the explanation of the data of the audit, the number of applicants, the scoring rates, the impact ratios, and we of course have to call out the number of individuals with unknown demographics. That's really important, and if test data was used. So functionally, what happens with this is that it all goes on a web page or it all goes to a PDF file. It's like nicely formatted, and it's oftentimes linked in either like a large organization will have like a compliance page. Oftentimes it's there. Sometimes it's on the HR website. Sometimes it's both. Then finally, we have to make sure we notify the candidates. We kind of talked about this 10 business day thing. So this is a kind of a draft of notification language that you can put on the careers page. So Talent Screen uses an automated employment decision tool. Our AI-powered resume screening and tool assessment candidates based on relevant job qualifications. You can kind of read the rest there. So you're going to have to write this yourself. Like that's a model, but you do want to make sure that you're calling out the use of that AEDT. And as you see in that second paragraph there, we have to make sure that we are calling out how to do an alternative selection process or a reasonable accommodation. Okay, so coming to the end of our Local Law 144 discussion, Local Law 144 is important. Like it is a law, it's on the books, but it is relatively narrow. So there's lots of companies that need to get bias audits done, but there's also a lot of companies the law doesn't apply to. Either they don't have the right nexus to New York City specifically, or their tools that they're using are not ADTs. It is a disclosure law, not a prohibition. So there's nothing that local law 144 says you can't do. You can run tools that have terrible impact ratios, like it's not against this law, but it creates the transparency that is both sort of embarrassing to organizations that don't have the right numbers, and creates other sort of like federal nexus challenges if they're under those EEOC thresholds. The employer bears the compliance burden here. So even if a vendor is providing the AEDT, it's the company that's deploying it that legally has to do this work. Now, in practice, brands that buy an AI tech or an AI HR solution are going to push really hard on the vendors to pay for these audits, provide audit data to make it easy for them. So where the legal responsibility lies is oftentimes not in this market where the financial responsibility lies. Bias auditing is, I think, a really good skill. There are a lot of sort of non-AI uses for these bias audit skills. So I think this is a good thing to kind of have in your quiver. And importantly, this is governance work. This is not data science work. The calculations that we did today are extremely simple. You do not need like complicated databases. Like functionally, like we do this on a spreadsheet with like formulas built in. This is not complicated, right? What's important about this work though is that since the actual calculations are not challenging, this is much more about relationships. It's the relationships between the auditor and the organization. Oftentimes, in my experience, companies will have me come in and do this audit work. It's relatively brief. Usually we'll do it in 2 weeks. And then they'll say, well, you did a good job on that. You seem to know a lot about AI governance. Stay for this longer project. So I think if you are coming from the perspective of an aspiring AI governance professional, or you run a consulting practice, those are interesting ways to get into it. So I want to talk briefly about a transition opportunity. If you are someone who's interested in AI governance and you've listened to this and thought like, well, wait a second, like I can do that stuff. Like I can put those things together and get clients. I run an accelerator program through Michigan State University's Broad College of Business. And what's really important to me in this program is like my promise to students that you actually do this work. So what we talked about today is like, there's no multiple choice test here. Like that's not what I'm interested in. I want to teach you to do the actual work